Canon 3 Fidelity, sections 13 to 22, conflict of interest. Section 13, conflict of interest. A lawyer shall not represent conflicting interests except by written informed consent of all concerned given after a full disclosure of the facts. There is conflict of interest when a lawyer represents inconsistent or opposing interests of two or more persons. The test is whether in behalf of one client, it is the lawyer's duty to fight for an issue or claim, but which is his or her duty to oppose for the other client. Section 14, prohibition against conflict of interest representation, current clients. In relation to current clients, the following rules shall be observed. A lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless, first, it is shown that the transaction and terms on which the lawyer acquires the interest are fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can be reasonably understood by the client. Second, the client is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of another independent lawyer on the transaction. And third, the client gives written informed consent to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. B, a lawyer shall not use confidential information relating to representation of a client without the client's written informed consent, except as permitted or required by law or the CPRA. C, a lawyer shall not, by undue influence, acquire any substantial gift from a client, including a testamentary gift, or prepare on behalf of a client an instrument giving the lawyer such gift directly or indirectly. D, unless with the written informed consent of the client and subject to the application of the sub judice rule, a lawyer shall not make or negotiate an agreement giving the lawyer literary or media rights to a portrayal or account based in substantial part on information relating to the representation. E, a lawyer shall not accept compensation for representing a client from any person other than the client unless, first, the client gives written informed consent. Second, there is no interference with the lawyer's independence or professional judgment or with the lawyer-client relationship. Or third, the information relating to representation of a client is protected as required by the rule on privileged communication. F, a lawyer who represents two or more clients in the same case, in case there is a settlement or plea bargaining, shall disclose to all the clients the existence and nature of all the claims or pleas involved and the participation of each client in the settlement or plea bargaining. And G, a lawyer shall avoid testifying in behalf of the client except first, on formal matters such as the mailing, authentication, or custody of an instrument and the like. Second, on substantial matters in cases where the testimony is essential to the ends of justice, in which event the lawyer must, during the testimony, entrust the trial of the case to another counsel. Section 15, conflict of interest of a lawyer hired by a law firm. When a lawyer joins a law firm, it shall be the duty of the lawyer to disclose to the law firm at the earliest possible opportunity his or her previous clients that may have a potential conflict of interest with the current clients of the law firm. If there is a potential conflict of interest, the lawyer shall not act on the case or cases of the affected current client. Section 16, prohibition against dating, romantic, or sexual relations with the client. A lawyer shall not have dating, romantic, or sexual relations with a client during the engagement unless the consensual relationship existed between them before the lawyer-client relationship commenced. Section 17, Prohibition against conflict of interest representation prospective clients. In relation to prospective clients, the following rules shall be observed. A lawyer shall, at the earliest opportunity, ascertain the existence of any conflict of interest between a prospective client and current clients, and immediately disclose the same if found to exist. In case of an objection by either the prospective or current client, the lawyer shall not accept the new engagement. B, a lawyer shall maintain the private confidences of a prospective client, even if no engagement materializes, and shall not use any such information to further his or her own interest or the interest of any current client. Section 18, Prohibition against conflict of interest representation, former clients. In relation to former clients, the following rules shall be observed. A lawyer shall maintain the private confidences of a former client even after the termination of the engagement, except upon the written informed consent of the former client or otherwise allowed under the CPRA or other applicable laws or regulations, or when the information has become generally known. B, a lawyer shall not use the information relating to the former representation, except as the CPRA or applicable laws and regulations would permit or require with respect to a current or prospective client, or when the information has become generally known. C, unless the former client gives written informed consent, a lawyer who has represented such client in legal matters shall not thereafter represent a prospective client in the same or related legal matter where the prospective client's interests are materially adverse to the former client's interests. Section 19, Corporate Lawyers' Conflict of Interest. In relation to organizational clients, a lawyer who represents a corporation or any organization does not, by virtue of such representation, necessarily represents any constituent or affiliated organization such as a parent or subsidiary. A lawyer for a corporation or other organization who is also a member of its board of directors or trustees shall determine whether the responsibilities of the two roles may conflict. In the event of the latter, the lawyer shall disclose the conflict of interest to all concerned parties. Section 20, Legal Services Organization, Conflict of Interest. A legal services organization is any private organization, including a legal aid clinic, partnership, association, or corporation, whose primary purpose is to provide free legal services. A lawyer-client relationship shall arise only between the client and the handling lawyers of the legal services organization. All the lawyers of the legal services organization who participated in the handling of a legal matter shall be covered by the rule on conflict of interest and confidentiality. Section 21, Lawyers in Government Service, Conflict of Interest. A lawyer currently serving in the government shall not practice law privately unless otherwise authorized by the Constitution, the law, or applicable civil service rules and regulations. If allowed, private practice shall be upon the express authority of the lawyer's superior for a stated specified purpose or engagement, and only during an approved leave of absence. However, the lawyer shall not represent an interest adverse to the government. Section 22, Public Attorney's Office, Conflict of Interest. The Public Attorney's Office is the primary legal aid service office of the government. In the pursuit of its mandate under its charter, the Public Attorney's Office shall ensure ready access to its services by the marginalized sectors of society in a manner that takes into consideration the avoidance of potential conflict of interest situations which will leave these marginalized parties unassisted by counsel. That's it. Canon 3 Fidelity, sections 13 to 22, conflict of interest. If you want to watch more videos like this, please like, share, comment, and subscribe. Thank you very much.